This presentation explores the historical development of forensic psychology, tracing how psychology evolved from an experimental science into a respected and influential part of the criminal justice system. By understanding this history, we can better appreciate how forensic psychologists contribute to courts, corrections, and law enforcement today. Wilhelm Wundt is widely recognized as the founder of experimental psychology. In 1879, Wilhelm Wundt established the first psychology laboratory, marking the formal beginning of psychology as a scientific discipline. His work introduced experimental methods that emphasize observation, measurement, and objectivity, principles that later became essential for applying psychology within the legal and criminal justice settings. During the late 1800s, psychological research on memory, perception, and attention began to raise questions about eyewitness reliability. Legal professionals started to recognize that human perception is fallible, which laid the groundwork for psychology's future role in courtroom decision-making. Hugo Munstenberg is often considered the father of forensic psychology. He strongly advocated for applying psychological principles to legal issues and argued that expert psychological testimony could improve the accuracy and fairness of trials. In his book On the Witness Stand, Munstenberg discussed false confessions, eyewitness error, and jury decision making. Although influential, his ideas were controversial, and many courts remained skeptical about whether psychology was scientific enough for legal use. Early courts resisted psychological testimony due to concerns about reliability and scientific validity. Judges were cautious about admitting expert opinions that could influence juries, which slowed the acceptance of forensic psychology within the legal system. Between the 1920s and 1940s, criminology and criminal justice became formalized fields. During this period, psychology began informing correctional practices, rehabilitation efforts, and offender assessment, strengthening ties between psychology and criminal justice. State versus Driver was one of the first U.S. cases to allow psychological expert testimony regarding mental capacity. This case helped open the door for psychologists to participate more directly in criminal trials. The Fry decision established the general acceptance standard for expert testimony. This ruling required that scientific methods be widely accepted in their field, formally recognizing psychology as a potential legal science when proper standards were met. During the 1940s and 1950s, psychological testing became more common in prisons. The focus on rehabilitation increased, and mental illness among incarcerated individuals began receiving greater recognition within correctional systems. The Supreme Court's decision in Brown v. Board of Education demonstrated the power of social science evidence in shaping legal outcomes. This case significantly increased the credibility of psychology and its influence within the judicial system. During the 1960s and 1970s, courts increasingly relied on psychologists for competency evaluations, insanity defenses, and risk assessments. Ethical concerns also emerged, emphasizing the importance of objectivity and professional responsibility. In 1985, the American Psychological Association formally recognized forensic psychology as a specialty. This milestone strengthened professional legitimacy, encouraged specialized training, and expanded psychologists' roles across the justice system. Please feel free to copy the link into your search bar to view a YouTube video about what a forensic psychologist is. The APA Specialty Guidelines, first introduced in 1991 and revised in 2013, establish ethical and professional standards for forensic psychologists. These guidelines addressed issues such as dual roles, objectivity, and maintaining credibility in legal settings. Please feel free to copy the link into your search bar to view a video of 10 key concepts of forensic psychology. During the 1990s and the 2000s, forensic psychology expanded into policing, criminal profiling, interrogation research, and court consultation. The field moved beyond evaluations to broader justice system applications. Today, forensic psychology emphasizes evidence-based practice, cultural competence, risk assessment, and reentry support. Modern forensic psychologists work across courts, corrections, and community supervision to improve outcomes and public safety. Understanding the history of forensic psychology helps explain current ethical standards, professional expectations, and courtroom practices. This evolution ensures that psychological expertise is applied responsibly within the criminal justice system. This timeline highlights how forensic psychology developed alongside the criminal justice system, not separately from it. Beginning with early scientific research on human behavior, psychology gradually earned its place in the courts as judges and practitioners recognized its value in understanding defendants, witnesses, and decision making. As criminal justice and criminology became formal disciplines, forensic psychology expanded into corrections, competency evaluations, and risk assessment, eventually gaining formal recognition and ethical standards through the American Psychological Association. Today, forensic psychology plays a critical role across the justice system by supporting evidence-based decision-making, protecting due process, and promoting fairness. Understanding this history helps us appreciate how psychological science continues to shape modern criminal justice practice. The sources listed here include foundational textbooks, APA guidelines, and scholarly references that support the historical development of forensic psychology and its role in criminal justice. This slide contains my design statement. Thank you for your attention, and go Dragons!